We've, of course, seen this bill, or at least variations of the bill, over the last several years. Many of us have been following it very closely. I know that proponents of the bill have stated multiple times that the bill is about public safety and that it specifically really targets and affects criminals, making our communities unsafe. Could you help me find where in the bill does it explicitly state that the language applies only to people who have been convicted of violent felonies or other serious crimes?
Representative Byrd.
Thank you, Madam Speaker. You use the word convicted, which is a legal term. An individual does not have to be convicted. For someone to fall under the purview of this law, they would have to be taken into custody by a local or state law enforcement agency, which they would have to have met probable cause and Fourth Amendment protections to have been taken into custody. It's at that time that federal immigration authorities will be contacted to determine if that is someone who is wanted by those immigration authorities. So they don't have to be convicted.
Representative Smith.
Madam Speaker, and thank you, Chair Byrd, for clarifying. So just to check for my understanding, it sounds like what you're saying is other folks who have not committed serious crimes or violent crimes would also be impacted by the bill if there is a detainer request, for example, on that person.
Representative Byrd.
Thank you, Madam Speaker, and thank you for the question. What's important to understand about this legislation is we're not going to treat a criminal alien differently than we would treat a lawful alien or an American citizen. So, for example, if I were to be pulled over in a traffic stop and the law enforcement officer would run my information through NCIC, and if the state of Georgia had a warrant out for my arrest, Georgia would be contacted and say, we have this individual in our custody, do you want them? So this bill does not treat an alien any differently than we would treat an American citizen in that type of situation.
Representative Smith, you recognize in question.
Thank you, Mr. Speaker, and thank you for the answer, Chair Byrd. You brought up a warrant for someone's arrest as being comparable to a detainer request. Isn't there a difference between a detainer and a judicial warrant or a criminal warrant that is out for someone's arrest?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. So Article 1, Section 8 of the United States Constitution gives the federal government plenary or absolute authority over immigration. We saw that a few years ago in Arizona versus U.S., where the Supreme Court explicitly reaffirmed that position. This has long-standing history in the United States that administrative warrants are constitutional. In fact, in the case of Abel versus U.S., a 1960 U.S. Supreme Court opinion, in that case, the Supreme Court went through the history of administrative warrants and said that has typically been the way we have dealt with removing an alien from the United States because it is considered a civil matter. And so administrative warrants have historically been the way we have done that in the United States.
Representative Smith, you're recognized in question.
Thank you, Mr. Speaker, and thank you, Chair Byrd, for the informed response. I appreciate the fact that you correctly pointed out that most of these immigration cases are civil matters rather than criminal matters. I want to move on to my next question, which really has to do with whether or not there's any exceptions carved into your bill for different types of undocumented folks who are targeted, unfortunately. Does the bill make any exceptions for asylum seekers? Or will they also possibly be caught up in this and subject to a detainer request that law enforcement is then required to comply with for that asylum seeker?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker, and I would take issue with your characterization of individuals being targeted, but nonetheless, what I would say is that there is no differentiation between whether you're a legal immigrant, an illegal immigrant, an asylum seeker, or a U.S. citizen. If you find yourself in custody, federal immigration authorities are going to be contacted, and at that time, the determination will be made whether or not federal immigration authorities will take further interest in you.
Representative Smith, you're recognized in question.
Thank you, Mr. Speaker. Thank you again, Mr. Chair. You brought up an important part of the conversation, correctly so, that when it comes to a detainer request, there is no differentiation between the varying status of a particular immigrant, whether they're an asylum seeker or they're someone who has overstayed their visa. At the end of the day, if they have reason to suspect that you're undocumented, that there may be a detainer request for that person. Are you, and I'm trying to think of what some of the unintended consequences of that may be because of the very complicated immigration process that we do have in this country. Are you aware that contrary to perhaps some of the rhetoric from the President of the United States on Venezuela, that last year we actually saw a 35% increase in deportations of immigrants back to Venezuela?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. I wasn't aware of that data, but regardless, I want to make sure that it's clear and everyone understands as we have this conversation that, one, this isn't about national immigration policy. This is about how the state of Florida is going to deal with people that it finds in its territory, in its jurisdiction, that have committed some kind of crime. And I'll just go back to that this bill only applies to someone who has committed a crime and is in custody, when law enforcement is unable to determine their status, and that federal immigration authorities will be contacted to determine whether or not further action needs to be taken. And I will point out that last year, approximately 1 million names were run through the federal immigration database, and only about 15%, so about 150,000 did ICE actually take an interest in. So this isn't every single individual whose name is run through the database will then find themselves being in a deportation proceeding.
Representative Smith, you're recognized in question.
Thank you, Mr. Speaker. Thank you, Chair Byrd. You mentioned that this is only about folks who have now been detained or are now in custody. I'm going to address that in my next question, but I wanted to kind of hone in on the reality, which is that your bill will escalate deportations in the state of Florida because as a result and outcome, there will be more cooperation, required cooperation with ICE from local law enforcement agencies as well as many other state entities. Would it be fair to say that we will see more deportations in the state as a result of your bill?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. The state of Florida cannot deport anybody. There's nothing that we can do to place anyone in deportation. That's a matter for the federal immigration authorities to decide and determine. But what I would say is this, that if someone has committed a crime in which federal immigration authorities feel that that person needs to either be taken into federal custody or deported, then that's someone that we don't want in our communities, and that's why one of the reasons I filed the bill.
Representative Smith in question.
Thank you, Mr. Speaker, and thank you for your answer again, Chair Byrd. I'm aware of what some of the complicated outcomes can be of the policy, so I would challenge you to also consider and think about the fact that if someone is in custody because they allegedly committed a crime, we can't be the judge and jury all in one fell swoop and say, well, then that person must be a danger and they must leave. That's not always the case. But I digress. We know that there's going to be more deportations, not by the state of Florida, but in the state of Florida, because there are 775,000 undocumented people in the state. Would it be fair to say that if deportations will escalate across the board inside the state of Florida as a result of this bill, that we will also see an escalation of deportations of immigrants back to Maduro's Venezuela as well?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. I'd answer in this way. The state of Florida should help enforce but not be the gatekeeper for federal immigration authority.
Representative Smith, you're recognized in question.
Thank you, Mr. Speaker, and thank you, Chair Byrd. I'm glad that we're having this opportunity to have a really important dialogue on this. As I mentioned before, there's over 775,000 undocumented people in the state of Florida, and people have a right to be concerned with such a large population. Those folks have become our family, our chosen family, our neighbors, so it impacts a lot of us in a very personal way. Are there any jurisdictions in the state of Florida that you're aware of which are out of compliance with federal immigration law as it currently stands?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. And Representative Smith, thank you for that question, because I think you raise an interesting point. And it's why the bill does not define sanctuary city, it defines sanctuary policy, because this is one of the I'll call it a game, the games that some local law enforcement agencies and some municipalities have played, where they don't define themselves as sanctuary cities, but they have a policy not to cooperate with federal law enforcement agencies. So that's why, once again, we defined it as a policy, not as a sanctuary city.
Representative Smith for a follow-up.
Thank you, Mr. Speaker. Thank you, Chair Byrd. I've read through some of those nuances, and what I asked was whether any jurisdiction in the state of Florida is currently out of compliance with immigration law. My reading and my research tells me that no jurisdictions in Florida are in violation of federal immigration law. But let's take it to my next question, which is, my read on your bill goes beyond what current federal law requires of jurisdictions and agencies and different levels of government. Isn't your bill going way beyond really adherence to federal immigration law, but in fact is just creating, obviously, new state laws that go above and beyond what federal immigration law currently requires of our local governments and agencies?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. And that's one of the arguments has been made, is that this legislation is unnecessary because there are no sanctuary cities in the state of Florida. And so I would say, I'd answer to that question, if that's the premise of the question, that there aren't any, then join me in passing this bill, because it will have zero impact. But on the other hand, if you're suggesting that we do have sanctuary cities or entities with sanctuary policies, then we as a state, and the U.S. Supreme Court has said this, that a state may make federal policy state policy. And so the purpose and intent of this legislation is to say that where the U.S. Constitution is given plenary authority to the federal government to enforce immigration laws, that we are not being forced to do anything, but our law enforcement agencies will cooperate with federal immigration for those individuals that the federal government determines are a danger in our communities.
Representative Smith for a follow-up question.
Thank you, Mr. Speaker, and thank you, Chair Byrd. I do want to dig a little bit deeper into some of this policy rather than rhetoric from either side, which I know that we've engaged in as well. I've looked very closely at the bill, and you mentioned before that folks who are not already in custody won't really be impacted by the bill. I want to take a closer look to really understand that, because my understanding was specifically that if ICE wants to have, well, here's my question. If ICE wants to have a 287G agreement with a local government, which we know that a 287G agreement is essentially deputizing local law enforcement to do some of the work that ICE agents currently do. If they want to enter into that 287G agreement with a county law enforcement agency, but the county does not want to enter into that 287G agreement, has that act essentially created a sanctuary policy in violation of this law?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. As I understand current law, yes, if a law enforcement agency wanted to enter into a 527G agreement, but the county chose not to, then they would be in violation of this law if it passes.
Representative Smith for a follow-up.
Thank you, Mr. Speaker, and thank you, Chair Byrd. I did some research on 287G partnerships. I know there's only 5 counties right now who are currently engaged in a 287G partnership, but when I looked it up, I read that some of these partnerships include deputizing local law enforcement agencies to do investigations of immigration status, that many of them go beyond just doing investigations within the prison system of people who are already detained to determine their immigration status, but that also they're going out into the communities and they are essentially finding out what members of the community in passing may be undocumented. Is that also something that would be impacted by your bill, since law enforcement agencies will not have the opportunity to not enter into a 287G contract if they don't want to?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. So in addition to the 287G agreement, the Florida sheriffs, in coordination with federal immigration authorities, have created the BOA system, or basic ordering agreements, which would also be another avenue which would allow a local law enforcement agency or a local municipality to cooperate with federal law enforcement without entering into the 287G agreement.
Representative Smith for a follow-up.
Thank you, Mr. Speaker. I have an amendment that will address the issue of potential racial profiling because of those 287G agreements. So I'm just going to move on from that for now, and I promise I'm getting very close to the finish line. On lines 205, starting in 205, the bill states that state entities, government entities, law enforcement agencies, that they're not required to provide ICE with information related to a victim or a witness to a criminal offense if the victim or witness, to your point earlier, in a timely fashion and in good faith responds with ICE's request for information. Is it fair to interpret the way that part of the bill is written, that they can still share the victim's information with ICE if they choose to do so, but they're just not required to do so?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. And Representative Smith, I always enjoy our give and take and your thoughtful questions, not only on this bill, but on many pieces of legislation. So the language there, and part of the reason why we chose the timely response and in good faith, is that when talking to law enforcement, and that's who I've spoken with in crafting this bill, is trying to provide a vehicle which they can work with. But every case is different, and we have several members of this body that are former law enforcement. I think they'll tell you that every case is very dependent and fact-specific and witness-specific and crime-specific. So to try to craft language that would cover every eventuality would be difficult, and so we went with broader language there. But to give the individual that is a witness or a victim the opportunity to participate in trying to get someone that has not only harmed them or who they've witnessed harm someone else, to get that person out of our communities that may be a danger.
Representative Smith for a follow-up question.
Thank you, Mr. Speaker. Thank you for the answer, Chair Byrd. We've had some experience in my community with encouraging the undocumented community as best we can to cooperate with law enforcement, because many of the victims and families and surviving family members of the Pulse nightclub shooting were in fact undocumented. And I just want you to understand that, telling them things like, hey, listen, they're not going to share your information with ICE as long as you cooperate in a timely fashion and in good faith. Oh, and by the way, we're going to keep your information on file for 10 years just in case. That is not a very compelling argument to get people to step forward to share their story as a victim or witness to crime. Something to consider. To another one of my amendments on line 129, you define a state entity in very broad terms to include the state or any office, board, bureau, commission, department, branch, division, or institution thereof, including the state university system and Florida college system. My goodness, this sounds like pretty much every level of government has been swept up into this bill. Does that also include our school districts?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. So once again, and I hate to sound like a broken record, but this legislation covers those who have found themselves in state or local custody for whatever reason for violating a state or local law or ordinance. So regardless of where that person is found, if they have committed a crime and have been arrested and detained, they will fall under the purview of this bill. We have exceptions for certain areas, but so for example, if someone commits a murder on one of our state universities, we're not going to give them the get out of jail free card because you committed the murder on a school campus. It's still going to apply. But here's one of the things that I think is really important, and that's what's been missed in this debate, is that when our state and local law enforcement authorities come in contact with an individual, and that individual cannot provide whatever necessary documentation to prove whether they're lawfully in the United States, they do not have the access to the federal immigration indices to determine the immigration status of that person. So we know, after news story of individuals who've been deported multiple times who come back into the United States and commit repeated crimes. So for example, if someone committed a domestic battery in Indiana and was arrested and imprisoned and released and deported, and that person comes back into the United States, is now under a different alias in Florida, when that person is in custody, even for a minor crime, until they are run through the federal immigration database, our local and state law enforcement officers cannot know whether or not that person is truly a dangerous individual and is someone who warrants additional attention beyond maybe the minor crime they committed here in Florida.
Representative Smith, as a reminder, you do have an amendment. When we come back to that amendment, you can talk more about this issue and debate it. But you are recognized for a question on the bill.
Thank you, Mr. Speaker, for the friendly reminder. I often forget. I have so many amendments that I've filed, I can't even keep track of them. Chair Byrd, thank you for the answer. We will get to some of that later, and I don't think that I've misunderstood your bill to go beyond just those who are in custody. My understanding, and please correct me if I'm wrong, the reason I'm talking about the definition of a state entity is you've wrapped all of these different state entities and levels of government into the bill as requiring them to communicate with and comply with federal immigration authorities when they have requests of them that are not related to detaining someone, because of course the school doesn't detain anyone. Isn't that the case, that all of those folks are required in many ways to cooperate and communicate with ICE under your bill?
Representative Byrd, you're recognized.
Thank you, Mr. Speaker. And you correctly point out that the only people who will be subject to the bill are those who are in law enforcement custody. So of course a school district isn't going to detain somebody, but university police could, and they would be required to cooperate. But the public policy behind what we're trying to do in the broad definition of state entity is that, you know, in our federal system, states and not municipalities are the constitutional unit of government. So we are saying, in essence, that the state is preempting the issue with regard to federal cooperation with federal immigration authority, and any governmental entity below the state cannot have a policy that differs from state policy.
Representative Smith for a follow-up.
Thank you, Mr. Speaker. Thank you, Chair Byrd. It sounds like our school districts are wrapped up into this as well based on what you've been saying, but otherwise, please correct me if I'm wrong. My final question, which speaks to one of my amendments, and I'm legitimately trying to understand, perhaps the answer to my question may lead me to withdraw the amendment. On lines 255, there's a provision regarding prohibited discrimination. It says that discrimination is prohibited except to the extent authorized by the U.S. and state constitution. I'm trying to understand why that language is in there. What are the cases where discrimination is permitted under the United States or state constitution? Representative
Byrd, you're recognized.
Thank you, Mr. Speaker, and that's an outstanding question, and I'm glad you asked it. As you know, this bill has passed this body for the last 3 years, and that language was contained in there. And so what I would say to that is that it's, you know, the state constitution as well as the federal constitution can be amended. And so while we have protected classes in there, there could potentially be some foreseeable amendment to either constitution, and we wouldn't want the legislation to be attacked constitutionally if some exception was created if that language wasn't in there. So it's almost as if it's a savings clause to the bill.